Everyone has the amendments? All right, so we will begin. Clauses 1, 2, and 3. Yeah.
Clauses 1 to 3.
The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stand part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill. Is Senator Welch here? Thank you. Attorney General, you have also proposed amendments.
Yes, Madam Chair. Which amendments incorporate those proposed by Senator Welch?
All right, Attorney General, let's deal with your proposed amendment 12. We will have to deal with
each
clause
proposed
4
section
systematically because there are several subsets of clause 4.
Yes,
okay?
Madam Chair. Well, there's no debate on the new proposed section 12 if you wanted to, as opposed to 12A.
Yes, correct. So let us move on to 12A. Attorney General.
Thank you, Madam Chair. Madam Chair, the Law Association pointed out, as did Senator Welch, that when we were looking at the issue of first description and we were looking at the concept of identification procedure being undertaken by the person who is doing the first description, that is the investigating officer, that the use of the definite article "the" was problematic because it confined it to just one person, and because the concept of the investigating officer is defined in the section on definitions, and you'd see that in section 12, which comes in the pages just earlier. With that in mind, and bearing in mind what Senator Welch proposed to us as well, that is that the first description can be done by any officer, quote unquote, we proposed the deletion of the word "the" effectively, and using "an," so that it could be any investigating officer, which catches the categories suggested by Senator Welch in his proposed amendments as well. So we agree with the amendments proposed both by the Law Association in submissions coming in December 2020, as echoed in part in a different way by Senator Welch, and therefore we propose in the proposed section 12A that we cause the amendments to "the investigating officer" to read "an investigating officer." And in the second part of that, you will see in proposed section 12A subsection 4B that we introduce "where practicable" as a concept. This comes from a suggestion coming from the Law Association in their written recommendations in December 2020. And if you see that at page 10 of the bill, Madam President, it is specifically to cause an adjustment to proposed section 12A, subsection 4B, and that would take care of what is identified at A, subsection B on the circulated amendments. In subsections, in paragraphs C and D, as circulated by me, this would take care of eliminating the cross-reference to under subsection 3 in both places. That is in subsection 5 and subsection 6, because there's no need to tie it back to "the investigating officer" as identified. So in summary, the proposed amendments to section 12A are that we move away from the defined entity of "the investigating officer." We take "an investigating officer," which would catch the submissions coming, as I understood them, from Senator Welch in the debate, but specifically catch the recommendations coming from the Law Association. And We introduced the concept of where practicable, because the Law Association pointed out in subsection 4 that it was difficult with the conjunction and between A and B to have a video or audio recording if it was not practicable to do so, and therefore we've taken on board their suggestion. And then in paragraph C and D, we propose to delete the cross-references which would have applied, because we're no longer slaved or confined to the investigating officer. Do you want me to traverse 12B?
No, let's deal with 12A first.
Yes, Madam Chair.
Any questions or comments? Senator Thompson, aye.
4B, is there, after recording, is there an of supposed to be there?
Madam Chair, 4B, as we propose it to read, after the words where practicable, have a video. So let's read that in context. So the SHAPO, the investigating officer, shall
Have
A
video or
and then B,
recording.
have a video or audio
audio
recording, and then we one second here. B, insert afterwards where practicable, have a video. Yes. Just let me get it marked up. So we
All
should-
right.
Yeah. So it'll
All
start
right.
with where practicable, have a video or audio recording. Your question is whether the word of should
No,
be
I was
there.
wondering if it's a verb there you meant or
Yeah.
the physical. The investigating officer
Yeah, it
shall,
should be
where
of.
predictable, have a video, audio, recording the eyewitness, or you want to have of the eyewitness?
See, so
So I'm
Madam
trying to
Chair,
figure out if it's a noun or verb or what
Yeah.
you want there.
the word of is missing. Thank you, Honourable Senator, for picking that up.
No, I'm not sure.
Let's
What you
just double
wanting?
check it. So where practicable, have a video or audio recording. A word is missing. The
not
eyewitness
sure,
giving
you
the
know.
first description.
Both could work, it depends on the meaning.
So shall have a video or audio recording
Shall ensure a
of the,
record
of the
the
eyewitness. It's
Which
of.
is given by the eyewitness is also recorded.
of.
And where predicted, have a video or audio recording.
So, Madam Chair, in the amendments as circulated in paragraph C, in 4, capital A, B, we have it there correct in subparagraph 4B by inserting the words where practicable before the words have a video, and inserting the word of after the word recording. Inserting the word of after the word recording.
Yes, Senator Vera.
Honorable AG, Senator Welch had talked about being overly prescriptive with all the things to include under 12A2C. Are we keeping those or?
Sorry, this is not in that which he has circulated, it's in his oral submission.
In his oral submission.
Would you expand on that for me, please, with your leave, Madam Chair?
My understanding was that he felt that by putting this in a statute, omitting any one of those things could actually be counterproductive because it is almost as though it's already prescriptive. And I was wondering if we were comfortable with leaving it as it is or leaving it open.
Senator Vera, Attorney General, could you, when you say leaving it as it is, exactly what you're referring to in the particular? We're dealing with clause 412A.
Yes.
Madam Chair, I understand what Senator Vera is pointing me to. He's pointing me to 12A subparagraph 2C.
C, correct.
And my answer is that I'm comfortable because, firstly, of the use of the word include, and then when you get down to Roman 8, such other particulars that may be relevant, so that it continues to speak.
Thank you.
Okay. So, honourable senators, the question is that clause 4 be amended to put the amendment, yes, Attorney General. So let me leave it and we'll go on to B now.
Madam Chair, just for your direction.
Yes, just 1 second. Let me ask Senator Welch.
Yes, that's what I was going to ask.
Senator Welch, you had proposed an amendment to clause 4 at 12A.
I had proposed the words "or any police officer acting in an official capacity."
Correct.
I note the Attorney General has sought to deal with that by changing the investigating officer to an investigating officer. However, it may well be that in actual practice.
Senator Welch, may I ask you to just turn your mic on?
Oh, it's not on. I'm sorry.
Thank you.
Yes, it may well be that in actual practice, what occurs in the heat of the commission of an offense and its reporting, that the first person to whom a description is given, if we take first description by its literal meaning, is that first police officer you would encounter when you enter into the police station, the one who is taking the report, or the first police officer who reports on the scene. Now, strictly speaking, that might not be an investigating officer because it may not be that a formal investigation has been launched or anything as such as yet. And this is why I have suggested a police officer acting in an official capacity to capture any police officer who might be like a first responder, so to speak, but who may not strictly qualify as an investigating officer as defined in the provisions as they are. Because the provisions as they are speak to an investigating officer being an officer involved in the investigation, which suggests some sort of intricate involvement. Yeah. And as Senator Lachmidi just pointed out to me, sometimes if your first responder could be the highway patrol person on the scene getting the details of that first description. So, subject to your views, Attorney General, I would prefer the wider or any police officer acting in an official capacity.
I understand the mischief that the recommendation is intended to address. The use of the acting in official capacity causes me a little pause because then a debate as to whether you're official or not official then ensues. We agree that the Law Association had captured it in a very precise way by saying that the investigating officer would always tie you back to somebody who's actually nominated for that purpose, and it presupposes only one individual. So we thought that there was merit in their submission on that. So we thought to address both purposes, we went to "and." But let's look at the definition. Investigating officer means a police officer involved in a criminal investigation. I think that the caution that was just put there was whether that person had to be assigned to that particular matter. But I thought that the language is wide enough for it to be any police officer at the scene or receiving the first report. I look at it in the context of Division 2 identification procedures. Before an identification procedure takes place, a record shall be taken by an investigating officer of the first description. That's a rather formal process. And then we go into the particulars of the record, etc., and we put it in. So we felt that from a drafting perspective, removing the to an would give us the flexibility for an officer charged with that first description responsibility catching it and formalizing that approach.
But, AG, just finally on this point, what did you say was the difficulty with the formula of a police officer?
So, or any police officer acting in an official capacity.
Because I mentioned that because that's what might actually happen in practice.
Right.
That's in keeping with the reality of the situation. That was to reflect the reality of what occurs.
I do understand, Madam Chair, if I may engage in this, yes? So I look at it in the context of subsection 3. The investigating officer shall ensure that the first description of the suspect given by the eyewitness has been recorded in the approved form before. So there's a routine that they're going to be put into now, other than just by way of a casual interaction. It certainly won't be the investigating officer, the identification officer. For the investigating officer, the format will have to be, the form is delivered, the first description would have to be then obtained, etc. We have now said that that does not have to be one individual. It could be any individual performing that function of capturing the forms, fill out, etc. So we do genuinely believe that we've caught the mischief from the Law Association's point of view, and as painted by you, Honourable Senator, when we read it in conjunction with subsection 3.
Right. Okay, so subsection 3 says he shall ensure. It does not literally mean that he himself must do it or an investigating officer must do it.
Yeah.
So he can ensure that by having someone else assigned to do it. Okay, I think that's perhaps fair enough.
Senator Welch, there's a second part to your proposed amendment.
Yes, which is in subsection 4 by deleting subparagraph B. Madam President, that's what you're referring to? Yes, let me look at
The deletion of video or audio recording.
video. Yes, we are, that perhaps should have read, we are practicable, because those are the words I propose.
Senator Welch, the Attorney General, in his amendment, has proposed the insertion of the words where
We are
practicable
practicable.
before the words have a video.
Yes.
So,
Yes,
so
yes, that would take care of that, because I do not think it is always practicable to have.
To mandatorily require it.
Yeah. And it would be unrealistic to expect a video recording to be made, to have a video in place to take a first description, a spontaneous first description given by a witness.
So in light of that, Senator Welch, are you still pursuing your amendments to 12A?
Well, my amendment to 12A is consistent with what the Attorney General now has here. We are practicable, the insertion of those words.
And therefore, are you pursuing it, or will you now withdraw it, having seen the Attorney General's amendment?
Yes, having seen the Attorney General's amendment, I would withdraw.
Okay. Can we deal with
B?
Attorney General, your B?
Yes, please, Madam Chair. Madam Chair, consequent upon the amendments that we proposed to 12 capital A, we propose that we take on board the same concept of an investigating officer versus the investigating officer, to make it specific now, because we're distinguishing between any general person and then the assigned and defined person, and that therefore flows from the amendments that we proposed in capital A as circulated.
Yes. Any questions or comments? Okay, so we move on to 12C. Senator Welch.
Yes, with respect to 12C, I had proposed, with respect to 12C, the insertion of the words, the investigating officer or identification officer determines that. Inserting those words after the word where. So in 12C, it would be 12C 4A.
So, Senate members, we go to page 14 of the bill as we are dealing with the amendment proposed by Senator Welch.
12C and the proposed 12C.
So this is effective. Where an investigator in charge considers it would be useful.
May I, Madam Chair?
Yes.
Yeah. So, Madam Chair, I thank Senator Welch for this recommendation. I understand what Senator Welch is driving at in the capitalized A to 12C that he's putting at is who is the person to make that determination. He was narrowing it down so that an identification procedure need not be conducted, A, where it is not practicable to hold so, and I understood his recommendation to mean, well, who would decide that? But I'd just like to refer the Honourable Senator to subsection 2, which is on page 13, which says, subject to subsection 3, an identification procedure may also be conducted where the investigating officer in charge considers that it would be useful. So it flows, reading the clause as a whole, the section as a whole, that A would be the discretion of the investigating officer, and therefore we don't believe that we need to add it in because it's addressed by subsection 2.
Right, subsection 2. That's the change made by subsection 2, where you have replaced the with an?
No, so C, we're looking at 12C.
12C.
The recommendation that's coming at us is amend 4A to say who's going to say so.
Yes.
Right? And what I'm pointing out is that if you look at 12C subparagraph 2, the person is described there. It is the investigating officer who makes that decision. So 4 must be read with subsection 2. Subsection 4 must be read with subsection 2.
With subsection 2.
Yeah. Because it is the investigating officer in charge of the criminal investigation who would consider it useful or not, or practicable or not.
Considers that it would be useful.
So we respectfully believe that the concern is addressed by reading it with subsection 2.
Okay. I was just thinking that by being a little more specific, it would remove any doubt on the issue.
I catch the concern, Madam Chair. I'd just like to point out that because this concept of who exercises the function is throughout subsection 12C, section C, having put it at 2, we didn't want to distinguish between two different categories of persons. We want that person to be the man in charge and liable at all points as either the person with discretion or with responsibility.
Okay.
Yep. And subsection 5 also says an investigating officer may also conduct an identification. So we've kept it consistent. Thank you, Veronica.
The B part of your amendment in subsection 5, deleting the word not. Can you just talk to those amendments?
Yes. Subsection 5, an investigating officer may also conduct an identification.
It's currently
Yes. An investigating officer may also conduct an identification procedure where, now the investigating officer under normal police practice, it's not best practice for the investigating officer to conduct identification procedures. But in certain circumstances, it is accepted that it can be done. And one of those circumstances is where the suspect and the witness are well known to each other and neither party disputes this. But the language of 12(5)(c) as it is says the suspect, he may do so where the suspect and the witness are not well known to each other. And so my suggestion is whether the drafter really intended to put "not" there, or whether my suspicion is that the drafter did not intend to have "not" there. So I have suggested that it be deleted, because where they are not well known to each other, the investigating officer should not be carrying out an identification procedure in those circumstances. So I submit that "not" should be deleted.
So, Madam Chair, if I may, what happened was at the Special Select Committee, the DPP gave us specific recommendations, and we took that as a committee, we took it on board. Specifically, the DPP had recommended that 12(c)(5) be inserted. That came from his written comments, which are circulated in the report dated the 17th of May 2019. And the DPP raised at the committee the case of Ronald James versus the state, 2009 UK Privy Council 12. It was the Trinidad and Tobago case. And so we had taken it carefully from the DPP's recommendations. Do we have that in the report here with us? I could refresh. I don't have the report with me now, but I'd taken a note of where it came from.
I see.
But in any event, if you look at the conjoint effect of subparagraphs C and D, so C is the suspect and the witnesses are not well known to each other, and neither party disputes this. We have A, suspect is known and available, suspect admits. B, suspect is in custody, eyewitness with no previous knowledge, saw. C, suspect and witness are not well known to each other, neither disputes. Or the witness claims to know the suspect, but the suspect denies this. The question is only whether one needs to condescend to both parties knowing each other and not disputing. But I think that is caught between the operation of C and D.
Senator Vera.
Just for the record, I have the DPP's recommendation
Lovely.
here.
Thank you.
First description. On the issue of information contained in the record of the first description at the proposed section 12A2C, it is recommended that other specifically required areas to probe the eyewitness are: 1, whether and if they have, how many times they had seen the person who committed the offense before, and 2, whether there was anything impeding the view of the witness as is required by the case of Lavend and the state, tabby at pages 467 to 469, a decision of our Court of Appeal which adopted the English decision of Turnbull. So that's what he said on it.
Let me just grab it.
Does he want it?
I don't know, I'm trying to get his attention. Does he want the report? Oh.
Madam Chair, in the submission that came from the DPP, specifically in reference to the case of Mark France and Rupert Vassell versus the Queen, 2012 UK PC, the DPP quoted for us paragraph 28 coming from Lord Carr, saying it is now well settled that an identification parade should be held where it would serve a useful purpose. We've adopted that. in John versus the State, which is the case that I referred to a while ago, 2009 UKPC, addressing the question of how to assess whether an identification parade would serve any useful purpose, Lord Brown considered three possible situations. The first, where a suspect is in custody and a witness with no previous knowledge of the suspect claims to be able to identify the perpetrator of the crime. We have that. The second, where the witness and the suspect are well known to each other and neither disputes this. Stick a pin on that one. And the third, where the witness claims to know the suspect but later denies this. The first of these instances, an identification parade will obviously serve a useful purpose. In the second, it will not. So the caution now is the paragraph here, the second, where the witness and the suspect are well known to each other and neither disputes. Let's cross-check that. Yeah. Okay, yeah. I'm going from first principle to make sure we got it right. So I'm thanking you for your observation, and I've now found where it came from.
He's going to take over now.
The suspect and the witness are, yes, the word not should in fact be removed from this section because it now accords with the case of John and the State as per Lord Carr.
Right.
So, Madam Chair, the recommendation coming from Senator Welch is welcomed and correct, and we've had a chance to check the Special Select Committee's specific report.
Well known to each other.
Have a D? Yes?
The D, again, is because this subsection 5 is really not so much concerned with whether the identification procedure should be adopted or not, but whether the investigating officer involved in the investigation should be the one conducting it. And what I'm saying is that that is normally regarded as bad practice, except for certain exceptional circumstances. And the exceptional circumstances is where the two parties know each other very well and they acknowledge knowing each other and there is no dispute. So it's okay in those circumstances for the investigating officer to be involved in the identification procedure. But anytime there is a dispute, the suspect says, I don't know this witness, even if the witness claims that he knows the suspect, but the suspect raises that as a dispute. Then in those circumstances, you have the neutral person, which is the identification officer, who is a neutral person under this legislation, who is not involved in the investigation. He is the one to conduct it. But if you look at the present paragraph D, it says the investigating officer.
I got you. It's a bifurcation. So argument number one, the exceptional circumstance would be permitted. In certain cases, you've identified the two, the first of which we have captured by the deletion of the word not in subparagraph C.
Yes.
So it accords with Lord Carr's description.
Yes.
The second aspect is you're cautioning that we'd run afoul of this position because we've got the wrong person. It's not the investigating officer who should be there. It should be another person. So your recommendation is to delete subparagraph D because you got the wrong person exercising that function.
Yes.
Yes?
Yes.
So I'd only refer now to the third aspect set out by Lord Carr and Mark France, and that is the third where the witness claims to know the suspect, but the latter denies this. The witness claims to know the suspect, but the suspect denies this. So that's where we had called D from.
So in those circumstances, an identification procedure should be adopted, but it should not be by the investigating officer who is involved in the investigation.
Mm-hmm.
So that is why I submit that these should be deleted from under 5, which states the circumstances in which the investigating officer may be involved.
So you're saying, had I put D with the other person, not the investigating officer, I would not be tripping it.
Yes.
Yes. Madam Chair, I thank you for allowing us this ventilation. Would you permit me a moment to just discuss this?
So then this over should come here, and then this should stop, full stop here.
Yeah, so that should be
And then we could do this separate. That in this circumstance, a different person will come.
clarification. if D is deleted, then I think it would be understood by implication that it would have to be the identification officer doing it.
That's
So
what that's what we're shopping for right now.
So there's-
just to be sure.
Yeah, so there's perhaps no need to try to amend it, D, but to delete it instead.
So, Madam Chair, first of all, if I could thank you for facilitating the exchange of ideas and submissions. Madam Chair, paragraph B of Senator Welch's, I think paragraph A of what Senator Welch recommended is caught by the proposals that we have. And when we come to that, we can perhaps convince you of that. But paragraph B is certainly welcomed. That is, by deleting the word not in subparagraph C of subsection 5, and by deleting subparagraph D.
General, perhaps you can advise Senator Welch as to your amendment to 12C.
Yes, Madam
That
Chair.
will treat with the A part of his amendment.
Yes, Madam Chair. Thank you. So, in the circulated list of proposed amendments on the AG's part, paragraph C on page 1, subparagraph A, would take us into the formula we just used in 12 capital A. So I am submitting that it would take care of the Law Association's recommendations and also be in harmony with the submissions coming from Senator Welch with respect to capital A under clause 12C. That's the second box. Madam Chair, the submission in respect of clause subsection 5, there's a further addition to that Senator Welch has suggested, and that would be to add the word I to witness. This is something that came from the Law Association submissions in December. They felt that we should make sure that we were targeting the eyewitness, which was the intent of the legislation. And so we are proposing in subparagraph C that we add the word I before witness, so that it is the eyewitness we're referring to. We agree that Senator Welch's submissions, as it relates to the word not in subparagraph C, are correct, and that subparagraph D should be deleted. If I could suggest as follows, in the circulated amendments of the Attorney General, I'm proposing that we accept, subject to consideration, as it relates to paragraph C, that we accept A, we accept...
Yes. Well, Attorney General, I think I know how we can treat with it.
Right.
Okay? So, because we can accept Senator Welch, having heard what the Attorney General has said with respect to A, which is your A part of your 12C amendment. Are you still going to proceed with that aspect of it? Part B has been accepted.
A, that is 12
Your
C4A?
Your 12C capital A, which deals with the investigating officer or identification officer, we had proposed a formula which we accepted in 12A, the amendment we just did. So we're proposing to maintain that, where we go with an investigating officer as opposed to the,
Okay.
which would respectfully lead me to requesting whether you would be minded to withdraw your capital A amendment in light of the proposals that we make. I was going to adopt your your B, capital B, into my own submission, because I don't know if you wanted to cleave the two, Madam Chair.
I see. So we are past C and D, that is 12.
We agree with you. We agree with you with
Right.
your C and D wholeheartedly. So I was
Right,
proposing to adopt those, take them into AG's amendments, which would, if you were minded, allow you to withdraw your amendment so that it's neater for the record.
Oh, I see. I see. So once you have the procedures, once you have accepted it and accept the amendment, then I would formally withdraw the suggestion.
If you're minded to, yes.
Okay. Yes, well, if you're having accepted it, then
Yes,
I would
and I
formally
thank you.
withdraw it.
Thank you very much, Senator Wells. So your amendments are withdrawn. Attorney General will just include now
Yes, Madam Chair.
in your C.
Yes. So, Madam Chair, so that our text reads correctly in the
Yeah.
circulated amendments,
Yeah?
CA would stand,
Yes?
CB in brackets, in subclause 5, Roman 1,
Yes?
in subsection C by deleting the word witness and
Yeah.
substituting the word eyewitness.
That's fine.
And now we have to put a Roman 2.
No.
Actually, no, we could say and, just after the word eyewitness, we would add in by deleting the word not. So that takes care of what Senator Welch had put by deleting the word not. And then, Madam Chair, in Roman 2, on the next page, we would delete what we have here, and we would say, instead of in subparagraph D by deleting, we'd say by deleting subparagraph D,
Yeah.
taking exactly what Senator Welch had proposed in Romans 1 and 2.
Senator Vera?
And just to tie it together, so between B and C, you'd have to put, having done so, semicolon, or, and at the end of C, full stop.
That's correct, Madam Chair. So in B, we'd have to subparagraph 5. Right, so in subparagraph 5, the first Roman 1 should be, Madam Chair, at paragraph B, delete semicolon and insert semicolon or. So if you look at this list of circulated amendments, Madam Chair, because we're deleting D, we have to adjust the or as it appears. So in my circulated amendments, where you see in the chapeau in subclause 5, dash, if you put Roman 1, in subparagraph B, in brackets, delete, open quotations, semicolon, delete the, can you do that? Normally I see them delete and then do it,
I don't know.
right?
That's
I understand, but normally I see you all say delete the semicolon, put semicolon or. Delete the word semicolon and put the
We're taking
Yeah,
off that here,
at
and we're also
C.
taking off the semicolon.
Oh,
by deleting the word open bracket semicolon. Yes, Madam Chair?
we have to be very careful
Yes.
with how we are drafting these amendments, and because I have to read it out.
Yes, Madam
Let's
Chair.
go back to your C.
Okay.
So we have in the proposed section 12C.
Yes.
We have A, which we're leaving.
Yes, Madam Chair.
Then we have B.
Yes. So,
Yeah.
right, so from the chapeau of B,
Yeah.
in subclause 5 dash,
Yes.
new Roman 1.
New, that's what.
Just
right.
above here, new Roman 1. In subparagraph B, delete the word open brackets semicolon and insert the word z, open brackets semicolon or, close brackets.
No, sorry, Attorney General. In subparagraph B, delete the word,
Open quotations,
yes,
semicolon, close quotations, and insert the words open quotations,
yeah,
semicolon, or close quotations. So put in the word or in.
yeah.
Then Roman 1 is renumbered to Roman 2. So
Yeah.
Roman 1, as set out there in subparagraph C by deleting, that becomes Roman 2.
Yes.
And we would have to, at the end of that, because we had gone, so the new Roman 2 would be in subparagraph C by deleting the word witness and substituting the word eyewitness,
Correct.
and by deleting the word not, and, as inelegant as that sounds, inserting the word, do you want to delete and say, yes, so we did all. By deleting the word semicolon
No, again, by
In
deleting the word
quotations.
not,
right?
Yes.
By deleting the word not
yes,
and deleting the word semicolon in quotations and replacing with the word full stop in quotations. In quotations. And I thank Senator Vera for that.
delete the word.
Consistent with the language that he has in his thing by deleting the word. So one would be subparagraph B by deleting the word semicolon and substituting the words semicolon or. In subparagraph C by deleting the word witness and substituting the word eyewitness, and by deleting the word not, and by deleting the word semicolon and substituting the word full stop.
It's
Then
just,
it goes to the
it's hold on. Or 12D.
Madam Chair, we propose in 12, not D, Madam Chair, E as in echo is our next one.
Yes, but it's sorry, it's listed as D.
Oh,
so let's just go with 4D.
Okay,
Yes.
4, sorry, I was
Yeah.
looking at 12D. So in 4D, we're proposing an amendment to section 12E by inserting after subclause 3, that which is circulated, which would read, an identification officer conducting an identification by verification under subclause 1F shall ensure where practicable that the procedure is recorded by video recording. This comes from submissions coming from the Law Association in December 2020, and we accepted their recommendation. It is to keep it in harmony with the practicability of recording any statement as opposed to the mandatory use of it, but also to make sure that other methods of identification were equally caught with video recording where practicable.
Any questions or comments? So can we move on to clause 4E? Senator Welch, you have an amendment to E?
Yes, Madam President. With respect to the present paragraph B, it really has to do with the order of priorities under 12E1. There is a paragraph B, which I am submitting should be moved down and should become paragraph D. So it's presently B, and it should be moved to D. So what is presently C and D would move up to B and C respectively.
So, Madam Chair, it's to put video as number 4 in the ranking of priorities as opposed to number 2. Just putting it quite simply.
Yes.
Madam Chair, if I may, this was the subject of a significant amount of debate at the Special Select Committee. In fact, we spent days discussing this. And the consensus coming from the multiple stakeholders, DPP, Judiciary, Legal Aid, Criminal Bar, Law Association, fell with video coming in at number 2. So we went with the preponderance of submissions for the ranking of priorities. And because we've had so much consultation on the issue, I regret that I would urge you to keep with what is proposed here, because we had had the benefit of a lot of time in discussing this particular issue. But I wish to remind that subsection 2 prevails as well, notwithstanding the order of priority established under 1, which is what we're looking at. where it is impractical or circumstances are unsuitable to conduct an identification procedure in the order of priority, the identification officer shall offer the next identification procedure in order, etc. So there is a degree of flexibility in this position depending upon practicability or circumstances.
I see. Perhaps, Attorney General, I could perhaps say, I have heard what you said, and I recognize the flexibility you refer to in respect of subsection 2. But perhaps I can still articulate why I made the recommendation. Because my concern was that with respect to the video medium, there is another provision which makes it very clear that when you are using this measure of identification, the suspect is not present to witness it or is totally unaware of it.
Yes.
He is not involved in that process
Yes,
at all.
that's correct. Yes.
Whereas with C and D, the suspect is in the public place and is part of the process and can be immediately advised that X has taken place, you've been pointed out, etc. My concern was we should have the participation on something as important as the suspect being pointed out. We should have the participation of the suspect as much as possible and in priority to a procedure where video images are taking place in a room somewhere. He is totally unaware of it or not familiar. Yes.
Madam Chair?
So, okay.
If I could jump in, and I know that perhaps you'd join or rejoin. Yes. Thank you, Madam Chair. Madam Chair, I recognize the care and caution that Senator Welch is pointing us to. That is the knowledge and consent of somebody whose rights are potentially going to be affected by a process to follow. The technocratic team with me referred me to the regulations which say that you'd be shown the photographs, etc., beforehand. But my point out to my own team was, yes, but that's subsidiary legislation, this is primary. And therefore, you would have to read the subsidiary as subsidiary. And that therefore there is merit in looking at the traditional mechanisms. I could always, with a witness who was afraid or who demonstrated circumstances that best led us towards video and moving images, we could go through the priority there. So I'd welcome the views of the larger Senate on this particular issue of priority, because I can see merit both ways. I know the regulations, albeit subsidiary, would have the effect of alerting the representatives of the accused that the exercise in the back room was going on with their knowledge of the photographs, etc. But I can also recognize that that is subsidiary legislation as opposed to primary. So could I ask for further consideration on the floor? I'd like to hear the views of senators.
Well, I can't force a senator to make a comment.
Well, if so.
Senator Welch has indicated his position. I don't know if anyone else has a question or comment to make. Senator Vera?
Just to echo what the Honorable Attorney General said, this was an area that was particularly thorny, and we had a lot of debate on it. I believe the police also made some strong recommendations on this particular subject, if I may quote from them. They said 12E, the order of priority should be rearranged. They were talking about the original bill. to place identification parade in accordance with 12K as the first priority,
We did.
identification in a public place with consent in accordance with clause 12M as the second order of priority, while video medium drops to third order of priority, and identification in a public place without consent and identification by confrontation retain their fourth and fifth respective rankings. I personally am comfortable with the bill as it is cast, but you know, everybody has their own sense of where the priority should lie. And
So it appears to some extent that this particular stakeholder, which is
The TTPS.
the police officers,
So
to some extent suggested a rearrangement.
their difference would only be that the without consent comes after the video,
Right.
which would make sense if you look at it that way. Again, my general reluctance in touching it is that we had a significant amount of consultation on the issue, but I can see the merit of the case being put either way, and obviously I'd like us to get this right.
Yes.
Perhaps it is, if we were to move paragraph B down to third in line as opposed to fourth, that we could perhaps see the logic of that, because without consent would be better, and by far better than putting somebody off into the crowd and they don't know about it. Because that would mean that the video and the crowd without consent would be sort of pari passu.
I see your point, but without consent does not necessarily mean the suspect is unaware.
Without knowledge, yeah.
That the suspect doesn't
True.
know what's happening, you know.
True.
It means he knows what's happening, but it is without his consent. He is invited in a public place. But he is still in a better position, even though it is without his consent. He is still in a better position. I'll just hold on for the HA as he's consulting.
So, Madam Chair, I know you're being very indulgent with us this afternoon.
Yeah, he isn't there. He's
The
witnesses.
difficulty that I have, I can see the merit. Not only did we have the consultation and the result of this, but the urge was really to push us towards technology. Obviously, one has to be very careful in saying that. Technology ought not to trump rights and
Yes.
positions. I mean, certainly the weight of the evidence falls into issue when you're looking at it in court to say, well, look, this happened in the back room with moving images where the person didn't even know. I know that there would be a story to that. But
Because you see, if I may interject, AG, even let's say with the identification parade with the one-way mirror situation, although the suspect isn't seeing the witness,
he knows it's going on.
he knows what is going on, and it is done in a manner which, according to the practice and guidelines, the audio must be clear so that he's aware of what is happening. But you see, my concern as well is that we are introducing technology and we are giving it a priority over what currently exists. And the practice that currently exists is one in which the suspect is aware of what is happening.
a moving video doesn't hurt the section.
Madam Chair, if I could say that, having had discussion on this issue, that we'd be willing to adjust the order of priority as suggested by Senator Welch. I wish you were at the Special Select Committee, but I welcome you here in the Committee of the Whole. So, Madam Chair, the proposal at clause 12E, as circulated by Senator Welch, which is A in subsection 1 by renumbering subparagraph B to D and then renumbering, we would be prepared to accept this submission wholly.
Thank you, Attorney General.
No, thank you.
So in this particular instance, I will now put the amendment of Senator Welch. We will deal with it right now.
Sure.
Okay? So the question is that clause 4 be amended at 12E as circulated by Senator Welch. Those in favor, say aye.
Aye.
Those against, say no. I think the ayes have it. No. So we move on. So we now move on to Attorney General. We have dealt with your 12E as well, so we now move on to 12G. Senator Welch.
With respect to the present bill, 12G4B, my submission is that may shall be replaced by shall. And it relates to the situation where the representative of the suspect is unable to attend the identification procedure within the prescribed time. Currently, as it is, the bill says the identification officer may appoint a justice of the peace to protect that interest of the suspect. And I am submitting that where the representative is unable to be there.
Is B.
Sorry, Madam Chair, we agree wholeheartedly.
Oh,
Yeah.
very well.
Yes.
12G4B. But it's not B.
Yeah.
Question is that clause 12G be amended as circulated by Senator Welch. Those in favor say aye.
Aye.
Those against say no. The ayes have it. The amendment to 12G as circulated has been accepted. Attorney General, you have an amendment to 12G as well?
Yes, please, Madam Chair. Madam Chair, in keeping with the need to clarify who this identification officer is and what form and function, we propose that we amend the chapeau to 12G1. You see it at page 20 of your bill. Just after instead of the words he shall be, we now specify that shall be as circulated. The identification officer shall ensure that the suspect is. This brings some clarity to the legislation as recommended by the Law Association in their December 2020 submissions.
Yes. Any questions or comments on the amendment as proposed by the Attorney General? I'm not putting these
Understood.
to the vote
Until the end.
Yeah.
Yes, Madam Chair.
Yeah. We move on. No, Attorney General, you have a 12G4.
Yes,
B.
Madam Chair.
Yeah.
This is where we were agreeing with Senator Welch that we change the word may to shall. So I can withdraw this F, if you will.
You accepted it already? So it's withdrawn.
Yes, Madam Chair.
We move on to Senator Welch's G, 12G.
Yes. Madam President, 12J is concerned with the identification procedure using video medium, where there is an eyewitness and one suspect, as well as where there is an eyewitness and two suspects. In the case of 12J1B, it stipulates that where there is one suspect, 9 images has to be shown before an identification is made. But under C, where there are 2 suspects, they are both placed on the same moving images procedure, and the number of persons is increased to 12. So where you have one suspect, it is 8 persons. Where you have 2, it is increased to 12 rather than, let's say, 16. My view is, I heard the Attorney General say that this is the current practice in England, and also it is reflected in our standing orders. I am of the view, however, that for the protection of the suspect and to make the process fair, one should have one suspect at a time. Notwithstanding the practice in England, one should have one suspect at a time, even on the identification procedure. Even though you have two suspects, they should be dealt with on two separate identification procedures, and they should maintain the number of persons that would normally be dealt with when you have one suspect. That is 8 persons. I see no reason for having 2 suspects on the same identification procedure. And lesser persons per capita making up the rest of the lineup, so to speak. So because of that, I have suggested in the amendments, in circumstances where there are 2 suspects, by showing the present paragraph be replaced by the following paragraph. In circumstances where there are two suspects, by showing an eyewitness moving images of one suspect at a time with similar images of at least 8 other persons who resemble the suspect, and ensuring that the witness is shown at least 9 images before an identification is made. So where you have 2 suspects, you treat them individually, just as would be the case where you have 1 suspect. Otherwise, it would mean when you have 2, their rights are to some extent being compromised, or the fairness in the procedure. And there's no logical reason for that, and I don't consider the fact that that is the practice in England to be a feasible explanation or justification.
Attorney General.
Thank you, Madam Chair. Thank you to the Honourable Senator for his submissions. Madam Chair, we specifically went this direction based upon the Law Association's written recommendations of the 10th of April 2019, where they asked us to consider in their written recommendations it should be made clear that only 1 suspect shall be included in an identification parade unless there are 2 suspects of roughly similar appearance, in which case they may be paraded together with at least 12 other people. So that's point 1. Point 2 is that the Police Standing Orders 29.8 provide, and I read here now, if there is 1 suspect, there shall be not less than 8 persons inclusive of the suspect on parade. However, if there are 2 suspects, there should be not less than 14 persons inclusive of the suspects. So the position is that the recommendations in the bill come not only from PACE D, but they come specifically from our local jurisprudence in Police Standing Orders 29.8, which have been with us for quite some time. We also found some comfort in that all of the stakeholders had taken this particular approach. I'm reluctant in the context of disturbing what has been agreed in the Special Select Committee, and with the benefit of all of this position coming from the multiple stakeholders, to touch this concern. And then I draw the caution that if we touch this in J, as in Jupiter, we'd have to look at it in K, as in kilo. And again, there were no recommendations from any of the stakeholders that we should disaggregate the suspects 1 at a time. In fact, the evidence and practice in Trinidad is that you can treat with multiple suspects, 2 suspects at the same time, provided these parameters are brought in. What is useful for consideration coming from Senator Welch is ensuring that the eyewitness is shown at least 9 images before an identification is made. How that gels with the 12 in the multiple suspects in J and K is therefore to be factored. So ensuring that the eyewitness is shown at least 14 images before an identification be made. So we're at the higher level at 14. So if I could respectfully, on the basis of the level of consultation that we engaged in and the written recommendations coming from the DPP, the judiciary, the public defender, law association, and also the legal aid authority, all of whom supported this particular approach. If I could humbly request the Honourable Senator to reconsider the position.
That I've heard what you said as to what the stakeholders have commented, but in my experience, which is, let me try to be modest.
We accept that it is profound, Senator.
It is somewhat vast. I have never encountered an identification parade where, in practice, where two suspects are placed on the same parade. Mm-hmm. I actually recall cases in which there have been more than one accused, and there have been separate identification parades. So, notwithstanding what perhaps is stated here, I can tell you the practice that I have encountered right here in Trinidad is that it's one suspect on a parade at a time, and in other jurisdictions where I have appeared, not as defense counsel, but as prosecutor, mm-hmm. It has also been separate. The same thing, yeah. Even though they may have had provisions which say otherwise.
Yeah, yeah.
So this is the actual practice, and I'm afraid if it presently exists in the standing orders, but they depart from that practice, they probably do so because they recognize that what they do in practice is far more fair than what is catered for. However, I'm afraid that if this is now legislated for, because this is the effect of this is no longer a guideline. This is being put into appearance statute.
No, I catch you loud and clear, you know.
They may very well
I've got you.
Change their practice to suit this amendment to the evidence. So I think in those circumstances, I may have to adhere to my suggested amendment.
I'm not slave to...
True. I've never. Both prosecuting.
I think he's conferring with
Oh, sorry.
Yeah. I'm going to read each.
So what you're suggesting already is to just delete B. So you should just read a lineup of persons for one suspect and at least 8 other persons who resemble. It was very shiny.
Yeah, remember I was telling you there was a more recent... 17th of December 2020. Yeah, remember I was saying there was a more recent one?
I did not know that. This is one I have.
Okay.
Madam Chair, had a chance to discuss with my team. So if I put it on the record, I agree that we need to be careful. We're not dealing with a code, and we're not dealing with standing orders and subsidiary, which are at best persuasive because they lack of consequences. I would be lacking in responsibility if I didn't take note of the considerable experience that the Honourable Senator brings to this bench, and I thank him sincerely for sharing it with us. I think that we ought to err on the side of caution, and the caution would take us into cleaving the identification as proposed by Senator Welch. In other words, and I agree with you, that I ought not to go with a code and practice which has been sustained in that subsidiary level when I'm looking at primary legislation, particularly because we're looking at codifying this thing into the primary law. So, Madam Chair, in those circumstances, I'd wish to accept the proposed amendments to clause 12G as proposed by Senator Welch.
Thank you, Attorney General.
So, Honourable Senators, the question is that clause 4 at 12G be amended as circulated by Senator Welch. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The amendment as circulated by Senator Welch is accepted.
Madam Chair, would you permit me to just say this for the record?
Yes.
Senator Welch would not be aware, but I have a record in the Parliament of when I give an undertaking, I keep it, including reserving on matters and then coming back to amend it if further consultation brings necessary. Other members who have been with me for a while know that if I say I'll come back to X, I do. I'm just noting, prior to proclamation, I usually go to all the stakeholders again to double check. If the result of the stakeholder commentary comes back that we need to have another look, I may very well come back to the Parliament to ask for another look, but at least I'd be vouched with reasons this time. So just putting it on the record with no disrespect that in the course of consultation for proclamation, we may very well have another look at a few things that are before us now. Thank you for allowing me that.
Yeah, that's appreciated. And Attorney General, what I should mention as well before we close off on this is that it was just brought to my attention by Senator Diana Ryan that the latest stakeholder comment from the Law Association, which is dated December 2020, actually supports the measure I've just adopted. So it appears that they have departed from the earlier
thank you.
which you referred to. And this was just brought to my attention.
Appreciated. Thank you so much.
We move on to 12K. There are amendments proposed by the Attorney General and by Senator Welch. Attorney General,
Madam President, with respect to 12K1, there is reference to the identification parade taking place in a room equipped with a screen, permitting the eyewitness to view the suspect without himself being seen. However, in later paragraphs, it is referred to as a one-way mirror.
so if I could just interrupt 1 second. I
He has made that
think,
change?
just 1 second, Senator Welch, Attorney General, Senator Welch, you both have amendments, and I think I am seeing or understanding that Senator Welch's A and D mirror some of your amendments, Attorney General?
Yes, Madam Chair. We recognize and we thank Senator Welch for pointing out the inconsistency between the use of screen twice and the use of one-way mirror once. And what we've done is we've harmonized all to one-way mirror. So the amendments, as we've sought to capture it in that circulated on my behalf at G in 12, is a proposed amendment to subclause 1, 6, and 10, so that we, in 1 and 6, remove screen and use one-way mirror, which would appear in subclause 8. So we match up with what Senator Welch is saying. We had proposed also to remove the offending words on request in subsection 10, so that you are automatically provided with the information as opposed to having to ask for it, because the general rules of disclosure would have required that anyway.
So that the only, Senator Welch, you have an amendment at B and C? So can you speak to that, please?
Yes.
Thank you.
Madam President, just bear with me 1 second. Yes, with respect to 12K2B, it would be consistent with the amendment that we spoke of earlier. That is one person at a time but in this case, it is with respect to an identification parade. Earlier, we had addressed it.
We agree. It would be in consonant with the amendments accepted earlier. Yes.
And then can we speak to C? Your C, Senator Welch?
Yes, in subsection 3 by deleting the words on request.
It's done already. We already did the vote on request already.
This is the one way mirror.
I believe the Honorable Attorney General has accepted that.
It's mirrored already.
No,
This,
C,
On
this is
request?
different.
C is different. C is the walking behind where the one-way mirror is not used.
C is at page 28, sub 8.
So you had asked for it to be deleted. That's the where one-way mirror is not used and an eyewitness, which is to walk along the back of the parade. That was a recommendation that came specifically from the DPP. He was very strident about that inclusion. Your recommendation is to delete that.
Yes, my concern with it is that it caters for where a one-way mirror is not used on an identification parade. But my concern is that this is somewhat inconsistent with the rest of the provisions which dictate that a one-way mirror must be used. The provision we have already looked at speaks to the use of a one-way mirror in compulsory terms for an identification parade.
Not as it relates to 12K1. So an identification parade shall be conducted in a police station or other building under control in the normal conduct in a room equipped with screen. All right, so we're going one-way mirror permitted. Right, so yes, you're correct that we're in the zone of identification with one-way mirror. The question is whether there ought to be a carve-out to that, which is if there's an identification parade but there is no one-way mirror but you're all facing forward, whether you can be allowed to traverse the back of the parade.
Right. Well, what I suggest, because practically that would be difficult if you are using a one-way mirror, because under the legislation, if 12K1 already stipulates that a one-way mirror must be used, then you cannot be speaking in 12K8 of circumstances where one is not used. So I suggest we replace 12K8 because 12K8 seems to be aimed at a situation where a witness wishes to look at the back of the persons on the lineup.
Sorry, Madam Chair, I'm just refreshing my memory as to why the DPP had suggested this. Apologies. I'm just going to look for it quickly because
Yes.
this particular subsection.
But perhaps I could perhaps before you look at it, suggest a solution.
Yeah.
It can be amended in a way to suggest the one-way mirror continues to be used, but the witness has the right to ask for the men to turn around and see their backs. But again, using the one-way mirror, through the one-way mirror.
Forgive me.
Because I think this is what it wishes to do. It wants to deal with a situation where a witness wishes to look at the back of the men as well.
Forgive my ignorance on identification parades, but do you have the right to ask the witnesses to turn around? Even if you're using a one-way, I would assume you do.
Generally, a witness can ask, can they remove their, if they have on hats, can all persons remove their hats? If the witness asks for a particular person to remove his hat, the identification officer will request them all to remove their hats. A witness can ask for someone to speak and say certain words. A witness can
Generally.
Generally speaking. A witness can even go to the back of the line and move around. But in order to facilitate that, we don't need to use the one-way mirror. One could have the one-way mirror and make a request that the lineup turn around.
Madam Chair, out of an abundance of caution, I do agree that we can at this stage delete it. If the consultation with the DPP gives me a cogent reason otherwise, I can always come back to the House and Senate and ask for it to be included with reasons attached.
Yes.
So I propose that we agree to the deletion of subsection 8 and obviously the consequential renumbering which would flow from that, and we have accepted the deletion in D proposed by Senator Welch. So we accept B, C, D, and E.
Perhaps, Attorney General, I will put Senator Welch's amendment
Yeah?
to the vote, and perhaps you can withdraw yours, because his has one, it goes one step further than yours. Yeah?
No, I go one step further in my G subparagraph B. So I would withdraw GA and GC. Senator Welch didn't pick up the use of the word screen in subclause 6.
Okay. It's up to 6. Yeah.
Senator Welch doesn't pick up 6.
Pardon?
Senator Welch does not pick up subclause 6. He only has 1.
Yeah, we know. He should
So,
have
all right.
in that way. So, yeah.
So, all right, yes, so let us try and get this. So, Honourable Senators, the question is that clause 412K be amended as circulated by Senator Welch. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. The amendments as circulated by Senator Welch to 12K are accepted.
And Madam Chair, for the record, if I could withdraw the amendments, I propose at G, on page 2 of the circulated amendments, I
Yes.
withdraw G, A, and C, but I keep B.
Right. So, Honourable Senators, the question is that clause 412K be amended in subclause 6 as circulated by the Attorney General. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. The amendment as circulated by the Attorney General to subclause 612K is accepted. So we took his B, right? So
Yes,
we voted on this one. Let me just put that because we haven't voted on any of the others. On to Q as circulated by
Look, Senator Vera has a question.
Senator Vera.
Thank you, Chair. Just to point out, AG, that if we're deleting 8, you'll have to renumber the paragraphs. So,
Not consequent.
I have put that on the record and renumber accordingly.
Yeah.
Yeah? Thank you.
So we move on to 12Q as circulated by Senator Welch. Senator Welch?
Yes. Madam President, with respect to 12Q, if I may just say something about the provisions overall and then tackle each to suggest the reason for the amendment. The effect of these provisions is that an interview must be, a video recording shall be made of the interview. And secondly, and if the video recording is impractical, then an audio recording must be made of it. And if a video recording and an audio recording are impractical, then the interview shall be recorded in writing. So essentially, the present practice is for an interview to be recorded in writing. What this proposed section seeks to do is eliminate the recording of an interview verbatim in writing and replace it with a video recording of the interview, followed by an audio recording. So writing comes last. And what this proposes is that having eliminated the written record of interview as we know it, the video recording mechanism, whatever it is recorded on, is what is put into evidence. My concern with that is that I think the traditional recording of an interview in writing should be maintained, and what can be done to accommodate this change is a provision which says that the the interview shall also be video recorded, so that you have both can be tendered in evidence in a court, the video record of the interview, as well as the written record, as opposed to the video recording only. And you want to say something? Oh. And I say that because it would create a nightmarish situation if the police following these provisions don't have a written verbatim record of an interview as we know it, and rely solely on video. Because when you present a video as evidence in court, each time you wish to make reference to that interview, you have to bring video equipment and set it up. If a jury retires and needs to look at an interview, you would have to set up video equipment in the jury room. In the course of a trial, on several occasions, sometimes very sporadic, you need to go back to an interview, whether it is the accused testifying, whether it is cross-examination, and so on. And you would have to be playing a video each time. Now, the present practice is, because I have been involved in cases where a video recording has been made of a written interview, so you have both. The present practice is you play that video record once, and you have your written record to back it up. And subsequent to the playing of that video recording, all future references can be made to the written record throughout the trial, which is a much simpler, easier, and practical process. Of course, the video record would always be there in case there is need to make some reference to it. So I maintain that we should continue to have interviews in writing. They should not be replaced exclusively by video recording. And what should be provided for is that the interview should be both in writing and video recorded, and they both be tendered in evidence. And the difficulty as well with the elimination, if I may point out, the elimination of the written record of the interview has given rise to a number of alternative measures to deal with its elimination, which are somewhat impractical. For instance, you now have to have a register of interviews. And how I see it is that that register of interviews now has to come only because of the elimination of the written record of interviews. And according to that register of interviews, the register of interviews must have the reference number of the interview, the name of the interviewee, the number, rank of the officer, date and place of interview, time of commencement, etc., whether a break was taken, and so on and so on. Now,
Okay.
when you have a written interview, it contains all these matters.
Thank you.
It contains all these matters, and it not only contains all these matters, but it shows the context in which a break has been taken, at what stage of the interview, what is happening, etc. Now, when you just take a register and you just put certain categories of information from the interview in that register, it doesn't explain the context. It doesn't explain what was happening when the person asked for a break or any such thing.
Thanks. Thank you very much, Senator Welch.
So.
Senator Vera.
Thank you. If I could echo Senator Welch and put it perhaps this way. Instead of doing a recording and then writing up a transcript as two separate and sequential situations, what I think Senator is suggesting is, as the interview is being recorded in writing, it is also being recorded in film. So that would ensure the integrity of what is written. And from an evidential point of view, instead of having to go back to the film the written document has already been authenticated and can be referred to throughout the course of the trial.
Yes. And one other difficulty, if I
Put
may.
quite simply, is I saw you do it. It wasn't
Yes.
beaten out of you, it wasn't coerced out of you, you had several shots, etc. I catch the point. Madam Chair, all of the submissions that came back, including the Law Association, was in full support of the law as drafted. The question is whether everybody missed the mark of removing writing. But that is not necessarily the case when you read the hierarchy of positions: video, audio, where not practicable, written, which is what Senator Welch very helpfully took us through in terms of priority. If I draw the example of what we're doing here right now, we're being videoed and audioed, and it's being transcribed. In the courts right now, the FTR technology, which we've taken the backlog down to 0 on, we have no more backlog of transcripts, etc., because we use mask transcription services. However, all of those things are materially different, one could argue, because a statement or a confession or an admission being given on an audio and a video without in writing, not only is a departure from where writing is at present, but it's very different from how the weight of the evidence is going to be viewed in the ground. So I catch the submission, I genuinely do.
And I think, if I may just add, Attorney General, because the writing is being eliminated, it now puts a burden on this provision, in order to make up for that, now puts a burden on the officer to record in the station diary the interview. So that would mean an officer, if an interview runs into, and I've seen interviews run into 20, 25 pages, you don't write it out, and now you have to go and record it in a station diary, 25 pages of interview. Whereas the present practice really is that in the station diary, what is presently done is a sort of summary of the interview.
He gets the point. The question is whether now how to recast it.
So we just have them both, according to the suggestion I made here.
Yeah. Do it as one exercise, kill two birds with one stone.
Yeah.
Madam Chair, I'm reminded of what happened when we were looking at treating with preliminary inquiries and paper committals, etc. And the steps that we took to get there, we didn't go wholeheartedly with a form of amendment, and that there may be, I'm mindful that notwithstanding stakeholder consultation, that the Senate is the Senate, and that this Parliament makes law as opposed to anyone else. So it is really up to all of us here seated to come up with this. Would you give me a moment just to have a quick look at this in context? I could flag right now, I still wouldn't want to lose the register of interviews, but I just need just a quick moment to ascertain something.
Honourable Senators, at this stage, the deliberations of the committee will be suspended for 10 minutes. We will return. We are standing down deliberations on 12Q, the proposed amendment, and we will return, the committee will return and resume at 7 p.m.